Hello, my name is Ed Harris, and I'm with the Philosophy Department at Texas A&M, and I'm here to help you with the ethics exam. I'd like to say a few things by way of introduction because ethics is a newcomer to the FE exam, as I'm sure most of you know. And the first question I think to ask is this: why has ethics been introduced into the FE exam? Now, I am not an engineer, and I was not privy to the inner councils where this decision was made, although I have been involved in making a number of the questions and in writing the introductory material in the review handbook. But I'd like to speculate on a couple of reasons because I think it's interesting to think about them. I think one of the reasons is that there have been a number of so-called engineering disasters that have increased the awareness of the public of the importance of engineering and the way it affects their lives. Now, I think the term engineering disasters is unfortunate in a way because many of these calamities were actually not the fault of engineers, and in fact engineers tried to prevent them. So in calling something an engineering disaster, we're not saying that engineers were necessarily at fault at all. But you naturally think of the Challenger or Hyatt Regency or other newsworthy calamities that, again, as I've said, have raised the public's awareness of the importance of engineering and its effect on their lives. There's another interesting reason that I think is probably important here. The increased importance of engineering ethics is, I think, an indication that engineers are becoming increasingly professionally self-conscious. Empirical studies that have been done for a number of years have shown that engineers don't identify with their profession in quite the same way that, say, doctors and lawyers do. That is, they very often think of themselves, first of all, as employees of General Motors or General Electric or whatever, and second, as engineers. Whereas most lawyers and physicians, for example, tend to identify first with their profession and second with their employer if they have one. I think this is beginning to change. Engineers are becoming aware of their importance, of their own ethical and professional standards, of their obligation to the public above all else, and I think it's in this context that the emphasis on ethics and the placement of ethics questions on the FE exam should be understood. So it's an interesting phenomenon, and I think you're going to see an increased emphasis on ethics and professionalism throughout your professional career. Now, let me tell you what I'd like to do this morning. My presentation will be in essentially three parts with possibly an addendum at the end, which deals with some things that I just learned about, say, 15 minutes ago. But the presentation that I have prepared is in three parts, and it goes like this. First, I want to talk a little bit about the introductory section on page 80 of the FE handbook entitled Ethics. I want to say some things about that section since I wrote a good bit of it. Second, I'd like to talk about the code, the NCAAS code, which is presented on page 80 and 81 of the FE handbook. And then third, I'd like to talk about some of the questions, the sample questions that are presented in the handbook, and think through them with you and help you to understand how you should go about answering these questions. Okay, the first item on the agenda is the introductory section called Ethics in the handbook. Now, this section has two parts to it. And I'd like to review some of the major items of this section, and it goes something like this. The first idea, and again you may have questions on these, the first idea in that presentation is the distinction between ethics and a profession. Most people have jobs, but not everybody has a profession. A profession has certain characteristics, and these characteristics have been studied by sociologists of the professions, and they look something like this. First of all, professions are based on a large knowledge base requiring extensive training, usually at the university level. Second, professions are particularly important to the well-being of society. Professional knowledge has a particular characteristic, and that is that it's not only learned, but it's a particular kind of knowledge. It's a knowledge that vitally affects the well-being of most of us. When we get sick, we really need the knowledge that a physician has. When we get in trouble legally, we really need the specialized knowledge that a lawyer has. And when we're in the area of technology, we really need, and in fact cannot do without, the knowledge that the engineer has. So professional knowledge is not only academically based, but unlike some academically based knowledge, it vitally affects the well-being of essentially every citizen. Now, another characteristic of professions is that they are at least supposedly self-regulating. That is, the control, training, and evaluation process that admits new persons into the field is usually done by professionals themselves. And the argument for this is, of course, that only professionals can do it. Only professionals know enough to regulate their fellow professionals. So lawyers can't regulate doctors, and physicians can't regulate engineers for the same sort of reason. Another characteristic is autonomy in the workplace. Now, you may wonder about this, because this is only true to a degree, of course. Nonetheless, it is true that professionals have always claimed that they should have more autonomy, that is, more ability to direct their own actions in the workplace than most other workers. And the reason for this is the point I made just a moment ago, that only professionals have the knowledge to regulate themselves. And finally, ethics is important in all professions. If I had an overhead on this, I would show it to you, but I didn't get one made, so let me tell you what it would be like. It would be a table that has two legs to it. And across the top of that table is written the word professionalism. And the two legs of the table are labeled professional knowledge and ethical standards. And I think it's very important to see that both of these legs are essential to professionalism, because professionals give the public information and skills that are important to their well-being, as we've said, and if the public can't rely on this knowledge, then the service of the professional really is undermined. And reliance on this knowledge implies these two things. Namely, you've got to be assured that the professional is technically competent, and you've got to be assured that the professional has ethical standards. And if either one of these are missing, you're in trouble if you're looking to that professional for help, and I think you can see why. Now, let's look back at another idea which is also important in that introductory section, and that is a notion of, and I don't have it here in those words, but a social contract, and that is what the term ethics and technical expertise refer to. There is a kind of social contract between the professionals and the larger society, in terms of which society provides professionals with a good living and a lot of social prestige, but at the same time they respect and require both of these characteristics, namely ethics and technical knowledge. And finally, the codes of ethics form, as we said, a contract between professionals and the larger public. And again, let me emphasize that if either of these two legs are missing, the public is in trouble. Now, there is another set of ideas in this introductory section that I think it's important for you to look at First of all, because I know I wrote some questions on these topics, so I know they're in the question bank. And secondly, because I think they will help you think about whatever ethics questions may come before you on the FE exam. Applying the codes in some situations is not problematic. These situations are what we might call paradigmatic examples or paradigmatic situations. For example, when you're offered $10,000 to specify a product on your design which is both the most expensive and the least reliable, we know that's wrong. There's no question there. That's a bribe of the worst sort, and we know that you are violating your professional standards. But all situations aren't that clear. The real world presents a whole variety of situations, many of which don't clearly tell you whether or not they are violations of the code. And there are three kinds of issues that make some situations problematic, and it's these three issues that I want to mention very briefly. The first of these is what I call factual issues. And I want to distinguish here between facts and factual issues. A fact is something that we know, something that is not controversial. A factual issue, on the other hand, is a matter of fact. It is a question of fact, but one which is controversial. And it can be controversial either because people disagree or because we simply don't know, even don't have any idea what the right answer is. So that's what a factual issue is. A factual issue is a question of fact that's in dispute. Now, as I've already indicated, facts can be just as controversial as moral issues. Engineers are fond of saying that they like facts and they like technical questions because they're always hard, quote unquote, as opposed to something like ethics, which is soft, quote unquote, or subjective, quote unquote. But that's not always the case. I've been around engineers enough to know that there can be heated arguments over the facts and over factual issues. And as I said, in many cases, they are just as controversial and just as difficult to settle. In fact, sometimes they're more difficult to settle than the ethical issues. Now, one final point here. Different factual assumptions can yield different moral conclusions. In other words, if the factual parameters of a case change, very often the moral evaluation of that case will also change. I remember about a year ago, after an engineering ethics class was over, a student came up to me and he was upset because he and his roommate had both taken the same engineering ethics exam, and they had come out with different conclusions. And the reason they had come out with different conclusions is because they had made very different factual assumptions. We always give a little narrative to a case, but a narrative that's a page long can't possibly present all the relevant facts. And what we tell students is that when they come upon a factual issue which is not resolved in the narrative, what they need to do is to indicate that this is a question of fact and to tell us what assumptions they're going to make. And as I said, he was upset because he came out with a different answer, having made different factual assumptions. Well, of course, my response was, why shouldn't you come out with different answers if you made very different factual assumptions? What would ethics be if you could make very different factual assumptions and yet always come out with the same conclusion? So facts determine the parameters of a case. You've got to be very clear about what the facts are and very clear about what factual issues you don't have the answer to. Okay, a second broad class of issues, maybe something you haven't thought about very much, is what we call conceptual issues. Now, a conceptual issue is a matter of definition. And if you look at this list, you will see just a few of the concepts indicated in the codes which can be subject to different definitions. What is a valuable consideration? Is a $5 pen a valuable consideration? Is a $25 meal a valuable consideration? Is a trip to Hawaii a valuable consideration? Is a case of CDs worth $100, $150 a valuable consideration? Valuable consideration is not defined in the codes, but as we all know, in interpreting the prohibition against allowing valuable considerations to influence your professional judgment, you have to make a determination on what constitutes a valuable consideration, what is outside the parameters of propriety in professional conduct. There are a lot more here. We don't have to go over all these in detail. What is adequate knowledge? What is welfare? The codes require that engineers place the health, safety, and welfare of the public paramount. How do we interpret welfare? There's some interesting discussions that have gone on this issue in the engineering profession. What does it mean to be truthful? Is withholding information not being truthful? The code requires engineers to reveal relevant and pertinent information, for example, in doing expert witnessing. But how do we define relevant and pertinent information? The code doesn't define it for you. When does something appear to influence professional judgment? When does something directly or influence professional judgment? These terms are not defined in the code. They can be sources of disagreement, and you will have to make these determinations. And the first thing is to be conscious of when you are dealing with a conceptual issue. Now, the third category of problems is what I refer to as conflict issues, or what the write-up also refers to as trade-offs. One of the areas where code interpretation can be difficult is when you have to trade off or balance conflicting ethical demands. For example, how do you balance cost versus benefit? How do you balance the obligation to employers and clients versus obligations to the public? How do you balance health and safety versus cost? How do you balance getting out a design in a speedy and expeditious way versus being sure that your professional work is up to snuff in terms of quality? And these can often be rather difficult decisions. Now, I'd like to turn to the code that is presented on pages 80 and 81 of the handbook and go through those provisions essentially one at a time and talk about some of the issues that are important for you to remember when you answer the questions. Now, the summary that I have here is not in the words of the code in most cases. These are my own words. I've tried to put this in my own words because you have the code in front of you. You can read that. But to put them in my own words as a way of emphasizing certain features of the codes that will very likely appear on some of the exam questions that you have. So let's go through these one at a time in terms of the outline that I have, and then we'll look at some questions. Now, all engineering codes these days begin with the statement that the first obligation of engineers is to the public welfare. Now, this has not always been the case. At one time, the primary loyalty of an engineer was supposed to be to his or her client, not to the public. But over the years, the codes have evolved, and I think it's part of the increasing self-consciousness of engineers that this has happened. So that now every code you'll see has, usually as its introductory statement, the first obligation of engineers is to the health, safety, and welfare of the public. If you'll look at the second part of my summary, you'll see that I've expanded this just a little bit. Registrants have a responsibility only to notify their employer or client and such other authority as may be appropriate when they believe their professional judgment is overruled in circumstances that may endanger, and here's the word again, the phrase again, the life, health, property, or welfare of the public. So this particular code, the NCWS code, also introduces the word property, but the usual formulation is health, safety, and welfare. Let me point out one other thing about number 2. Registrants have a responsibility to notify their employer if they believe an issue of public welfare as is at stake. But that's the only responsibility that the code imposes on you. After you have notified the person in charge that you think there's an ethical issue here, the code imposes only a minimal standard. Now, you may well think, in fact, I hope you do think, that this minimal standard is not sufficient. That merely to notify someone of a problem when this person chooses to disregard it may not be sufficient. But remember this, the code only sets minimal standards. It does not set ideals. It does not set the very highest standards. It sets the minimum standards below which you must not fall. And that's precisely what this is. So keep that in mind. That may be important in answering some of the questions. Number 3, registrants must include all relevant and pertinent information in reports, statements, and testimony, and this includes expert witnessing. You may not leave out or fail to mention such information. Let's say that you're doing expert witnessing and you are told by your lawyer, counselor, who's hired you, that you should not reveal any more than you have to. Now, sometimes there are legal restrictions here, and sometimes you are not permitted to speak as freely as you would like. But the code says that it is a violation of professional standards to withhold information. And that applies in expert witnessing and in other cases as well. Okay, number 4. Public statements may not be made when engineers do not have adequate knowledge of the facts, and engineers must identify interested parties on whose behalf they are speaking. It is not a violation of the code to be hired by somebody. It is not a violation of the code to speak on their behalf. It is a violation of the code not to identify those on whose behalf you're speaking. It's a violation of the code not to identify the person who's writing the check. Okay, number 5. Engineers may not associate with anyone engaged in fraudulent or dishonest business or professional practices. Now, there's an area where there are several conceptual issues. That's certainly not the first case, but I think here they may be particularly important. First of all, what constitutes fraudulent or dishonest? And secondly, what constitutes association? And then there's another interesting issue. Does this restriction apply only to professional conduct, or does it apply to personal associations as well? Now, the code seems to say that this restriction on association applies only to your professional associations. Some interpretations are broader than this. In fact, I have seen questions that seem to imply that it is unprofessional to associate with fraudulent and dishonest people even in your personal life. That's an issue, I think, of interpretation. What the code seems to say is that, again, at the very minimum, you must not have professional associations, for example, with companies that are known to be dishonest or fraudulent. Now, number 6. If you have knowledge of code violations, you must, and this is a quote, provide the State Board information and assistance necessary to the final determination of such violation. Now here again, there's an interesting issue of interpretation. When the code says provide, what does it mean? Does it mean you must volunteer this information on your own? Or does it simply mean that if the Board of Registration sends out an investigator, you must answer all the questions honestly and truthfully? Some of the questions I can tell you, because one of them is on one of them is a sample question that we're going to look at in a minute, seem to assume that you must actively report violations to the State Board. But that is, I think, an issue of interpretation. Now, let's look at the third and final section of the code, obligations to employers and clients. You must not undertake assignments unless you are qualified by education or experience in the specific technical fields. Now, there's a distinction here that may be important in answering some of the questions. Look at what it says. It says you may be qualified either by education or experience. It is not a violation of the code to accept an assignment in an area where you didn't have a class if you are professionally qualified due to experience or study after your classroom days are over. But of course it is a violation of the code to accept an assignment in an area where you have no expertise. But remember, your expertise is not limited to classroom activity. Okay, now let's go to the second. You may not affix your signature or seal to any plans or documents unless A, you have competence in the field, and B, the documents were prepared under your direct control and personal supervision. Now these are very, very important provisions. And I think the bet is good that you may have a question on this provision. And remember what it says. It says that you must, number one, have competence, but number two, you must have direct connection with the work itself. And this provision is further expanded in point number 3, which we can look at now. You may accept assignment for coordination of an entire project, provided that each design segment is signed and sealed by the registrant, who must also be registered, of course, responsible for that design segment. So again, you may accept assignment for coordination of a project, but not for, you may not sign documents unless you've been directly involved with them. So make that distinction between coordination and signing off on a document. It's one thing to coordinate a project, it's one thing to sign off on documents. Number 4. The exceptions to the prohibition of revealing information obtained in a professional capacity are when the revelation is authorized or required by law, or when the client consents. Evidently, breaking confidentiality to protect the public is not authorized unless it is specifically required by law. Now, that's an interesting provision. It's actually one that I have some ethical problems with. Because given the fact that the code says the interest of the public is paramount, why would an engineer not be justified in breaking confidentiality if it's necessary to protect the public, particularly if life is involved? But the code says otherwise. The code says the only exceptions to breaking professional confidentiality are consent of the client and when a court of law or some other legal power orders you to do so. That's what the code says. You may or may not agree with it ethically. I think this is a good example where you need to introduce your own ethical ideas into an elaboration of your professional responsibility. It is possible that the codes are wrong. It is possible for the codes to change. They have changed in the past. They will evolve in the future. Just to give you another example, this code has nothing to say about the environment. There are only 2 professional codes that say anything about the environment at the present. One is the IEEE code, excuse me, and another one is the ASCE code, which now has an extensive section on the environment and on sustainable development. With time, other codes will introduce some consideration of the environment. Mechanical engineers are considering it right now. It will probably be in the ASCE code within a year or two. And eventually the NCSS model rules will also reflect these changes. I think we can be sure of it. So one of the things that this particular provision suggests to you, I think, is that one of your responsibilities as a professional is to enter into a debate with your fellow professionals as to what your professional standards should be. And if you think they should change, then in your professional career you're going to have a chance to have this kind of influence. I'm not going to have it. I'm not in the inner circle, and I shouldn't be. I've been involved in some ways in a counseling and advisory position, but you're the engineer. You're the one that has the ultimate responsibility. It's your profession, and you have to make decisions as to what you think the standards of your profession should be. So with that little sermon out of the way, we'll proceed. Number 5, soliciting or accepting financial or other valuable considerations, there it is, from contractors, directly or indirectly, is prohibited. Now there's an interesting question here. How does this apply to vendors? The model rules don't say anything about vendors. Now you might say, well, that's included under contractors. I'm not sure that it is. But at least there is a question, as we all know, as to what kinds of amenities engineers should accept from contractors, and that's pretty clear, but also from vendors. And this is probably the first ethical question that you'll face as an engineer if you're a student and you're looking forward to your first full-time job. This may well be the first ethical question that you will face. What should you accept and where should you draw the line? Number 6, full disclosure of actual, potential, or apparent conflicts of interest is required, and a disclosed conflict of interest is permissible. Now this is an interesting provision, and I think probably basically a correct one. The code is saying that it is not a violation to have a conflict of interest. You're obviously on shaky ground if you've got a conflict of interest, and it's best to avoid them. But what is a violation of the code is a conflict of interest that is undisclosed. Now what makes this even more complicated is the code talks not only about actual conflicts of interest, but potential conflicts of interest. and even apparent conflicts of interest. So it's obvious that when you're in the area of conflict of interest, you're on something that's very sensitive professionally. And of course you can see why this is true. Conflicts of interest have the potential for corrupting your professional judgment. And your professional knowledge and judgment is the most precious thing that you have. It's what the public relies on. It's what you are selling. It's what you have to give and what you have to sell in the marketplace. And you want to preserve it from undue influence at all cost. So prohibitions against conflicts of interest, and particularly undisclosed ones, are very prominent and very strict in all the codes. Number 7, registrants may not accept compensation from more than one party for services pertaining to the same project unless the circumstances are fully disclosed and agreed to by all interested parties. And this obviously is a very tricky area when you're working for two different people within the same project. Generally, the code says you'd best avoid it, but at least if there is such a situation, again, the crucial thing is to be sure that it is fully disclosed and that the interested parties agree to your dual role in that particular project. Number 8, registrants shall not solicit or accept a professional contract from a governmental body on which a principal or officer of their organization serves as a member. Conversely, registrants serving as members, advisors, or employees of a government body or a department who are the principals or employees of a private concern shall not participate in decisions with respect to professional services offered or provided by said concern to the governmental body which they serve. Now here I could not abbreviate the provisions of the code, and I found that I could not put them in my own words. And so as you can see, these are essentially the words of this provision. This again is a very sensitive area. Government work or work in connection with governmental bodies is particularly sensitive for all professionals, and this limitation having to do with soliciting or accepting professional contracts where there might be the possibility of bribery is particularly sensitive. Okay, now let's turn to the final section of the code, obligations to other registrants. You must not represent or exaggerate the degree of your responsibility in prior assignments or the complexity of these assignments. You must not misrepresent past accomplishments or associations. This is very tempting. On a resume or on an advertisement for your firm, to say I was involved in such and such cutting-edge projects, when actually all you did was take minutes at a technical meeting. Now that's a violation of the code. You have to be very careful about representing your technical and professional experience. And again, I think this is pretty self-explanatory, but remember that you could well have a question on this issue, and the code is pretty strict here. Number 2, you must not give or receive a valuable consideration, there it is again, in order to secure work. You must not make a political contribution with the intent of influencing the award of a contract by a public authority. Now that's an interesting provision. The writers of the code were in a dilemma here, I think. On the one hand, it is obvious that a political contribution can be little better than a bribe. On the other hand, as citizens of a democracy, as a professional, you should not be forbidden from making political contributions, even maybe where your own professional work might be involved, or where you might have a contract. So the way the writers of the model rules have attempted to get out of this dilemma is to say, yes, you may make political contributions. You may even make political contributions in areas where you might be called upon to do professional work, but you must not be making these contributions with the intent of influencing the award of a contract. Now, how does somebody else know what your intent was? There has to be some kind of objective evidence here. And obviously this is a big red flag. If you cannot demonstrate that your intent was not to influence the awarding of a contract, then you'd better stay out. So again, this is a very sensitive area. Number 3, you must not attempt to injure maliciously or falsely, some big conceptual issues, directly or indirectly, some more conceptual issues, the professional reputation, prospects, or practice of other registrants, nor indiscriminately, another conceptual issue, criticize the work of other registrants. Now, this is an area where the codes have also evolved a little bit over the years. There was a time when any criticism, any public criticism of a professional would tend to get you into trouble. No matter how valid it was, no matter how much you might have the public interest at heart when you make these criticisms. Now, obviously, a complete prohibition of criticizing your fellow professionals is not in the public interest, because how can the public learn about indiscretions on the part of professionals, whether it be law or engineering or medicine or whatever, unless fellow professionals speak up? So this absolute provision has been relaxed, as it should be. But there still is a provision against indiscriminate criticism, against malicious criticism, against unfounded criticism, and that is also, I think, as it should be. So probably the code has struck the right balance here between an obligation to your fellow professionals and an obligation to your public. But remember that in some situations, as these conceptual issues indicate, it's not easy to interpret where you have transgressed the line between legitimate criticism of a professional which is in the public interest and illegitimate criticism of a professional which may be maliciously or self-interestedly motivated. Okay, that's my summary of the code. It includes most of the major issues and ideas in the code. There are a few that are, I think, even more obvious than anything here that I haven't gone over, and there are even a few that will come up in some of the questions. But now I'd like to turn to the 4 sample questions in the FE handbook and go over them with you, talk with you through these questions, and see why we come out with the answer we do. I think you'll see that when you've looked at the code and when you thought about its provisions, that these questions are really pretty easy to answer. Now let's look at the first one. Number 1. An engineer testifying as an expert witness in a product liability case should answer as briefly as possible only those questions posed by the attorneys. B, provide a complete and objective analysis within his or her area of competence. C, provide an evaluation of the character of the defendant. And D, provide information on the professional backgrounds of the defendants. Now I'm going to refer here not to my summary of the code, but to the actual code that you have in the handbook. And I'm going to refer here to section 1D, and you may remember that we talked about this a few minutes ago. You've got to include all relevant and pertinent information. Now, with that clue in mind, you can look at the options and I think very clearly see which one is correct. Number A is not correct, because if you answer as briefly as possible only those questions posed, you may not be answering everything that's relevant and pertinent. Number B seems about right in terms of that provision. Number C seems not to work, because you may not know anything about the character of the defendant. That's outside your area of professional expertise in any case, and so that one is pretty obviously wrong. And D is also wrong, because you may not know, again, anything about the professional backgrounds of the defendants, and that's not particularly within your area of professional expertise. So there's really only one right answer here. It's number B. Okay. Let's look at the second. A professional engineer, originally licensed 30 years ago, is asked to evaluate a newly developed computerized control system for a public transportation system. The engineer may accept the project if A, he or she is competent in the area of modern control system, his or her professional engineering license has not lapsed, his or her original area of specialization was in transportation systems, he or she has regularly attended annual meetings of their professional engineering society. Now, as you look at these in connection with particularly Section 2A of the Code, I think you'll see that there's only one right answer, and it is A. You must be competent in the area in which you're asked to render professional judgment. B is incorrect, because the mere fact that your license is not expired doesn't give you competence in the area. C is incorrect, because you remember it's not the case that you must have had training in your early days in a given area. If you're now competent in an area, that's enough. So regardless of what your original area of specialization was, if you're now competent in the area, then you're now competent in the area. And D doesn't work, because merely attending meetings of your professional engineering society certainly doesn't give you professional competence. You may have never heard a paper on this particular area, even though you've attended every meeting. And even if you've heard a paper or two, this hardly makes you necessarily competent. So that's obviously wrong. There's really only one right answer, and it's A. Now let's look at 3. Both you and Smith were hired right out of engineering school by XYZ Company 1 year ago. You and Smith work in the same engineering section and have become friends through sharing lunch and breaks, as well as working on the same projects once in a while. Recently, Smith let it slip that he never actually graduated due to failing a required last-term senior course. Smith just listed himself as a graduate engineer on his application form. Smith is a nice person. Both of you are registered as engineering interns with the state registration board. You should, and here are the options: write a brief report on the situation to the state registration board asking them to investigate. Ignore it since Smith does a good job, thus the course must not really be important. C, write an anonymous letter to the company president stating that some engineering employees are not degreed as required. And D, begin avoiding Smith, because otherwise your colleagues may think you condone his behavior. Now let me refer you here to several sections of the code, 1D, 1H, and particularly 3A, which says that a registrant may not permit the falsification or the misrepresentation of their or their associates' professional or academic qualifications. And of course this is a gross violation of that requirement. But in addition, you remember that we also talked about this business of providing the state board with information and cooperating with the state board. Now, given those provisions, the only correct answer is A. You do have an obligation to report this violation. Merely ignoring it is obviously not reporting it, so B is not correct. Writing an anonymous letter is not reporting it to the board. Furthermore, the code requires you to cooperate with the board in an investigation. And if you've written an anonymous letter, obviously the board has no way of knowing who wrote the letter, and therefore you couldn't cooperate. So C can't be correct. And certainly simply avoiding Smith is not either reporting it or cooperating with the board, and it is in fact allowing a misrepresentation to continue. So again, the only right answer is A. Now let's look at the fourth and final one. You and your design group are competing for a multidisciplinary concept project. Your firm is the lead group in the design professional consortium formed to compete. Your consortium has been selected as the first to enter fee negotiations with the project owner. During the negotiations, the amount you have to cut from your fee to be awarded the contract will require dropping one of the consortium members whose staff has special capabilities not found in the staff of the remaining consortium members. Is your consortium's response in the negotiations ethical? Here are the options. A. Not if the owner is left with the impression that the consortium is still fully qualified to perform all the required tasks. B. Yes, if your remaining consortium members hire a few new lower-cost employees to do the special work originally intended to be provided by the consortium member dropped. C. No, because an engineer may not accept a contract to coordinate a project with other professional firms providing capabilities and services not under the engineer's direct control. And D. Yes, if in accepting an assignment to coordinate a project, a single person will sign and seal all documents in the entire consortium work. Well, again, the correct answer is A. And I call your attention particularly to sections 2B and C of the code, which require that engineers not sign in areas outside their competence, and also in the more general requirement that engineers not work in areas outside their competence. A is, as I said, the correct answer, but let's look at B, C, and D. B says, yes, if your remaining consortium members hire a few new lower-cost employees to do the special work originally intended to be provided by the consortium member dropped. But this says nothing about the competence of these people to perform the work. The mere fact that you hire some lower-cost people to do the work doesn't guarantee that they're competent. Indeed, it may guarantee that they're not competent. So B is clearly wrong. C, no, because an engineer may not accept a contract to coordinate a project. But remember, we said that an engineer may accept a contract to coordinate a project with other professional firms. The problem is signing documents which were not under your direct supervision and control. So C is not correct for several reasons. D, yes, if in accepting an assignment you coordinate a project, a single person will sign and seal all documents in the entire consortium work. Well, of course, this is a violation of the code, because as you remember, a person may not sign or seal documents which were not under their direct control. So again, there really is only one correct answer, and it is A. I hope this has been helpful in thinking about the ethics section of the FE exam. I think you will find the questions, certainly of this type, to be pretty directly related to the code. If you've gone over the kinds of considerations that we've talked about, you should be in pretty good shape to answer these kinds of questions. Now, I will call your attention in closing to something that I just learned about a few minutes ago. I've never seen this book before in my life. It is this book, which you may be very familiar with, the EIT Review Manual. Now, there are some questions in this book which have a very different flavor from the ones that we've talked about. They are not necessarily related directly to the code, and they are in general much more wide-ranging. And in my opinion, quite frankly, the answers to some of these questions are much more controversial. I can tell you that when I was asked to write questions for the FE exam, I debated with myself quite a bit over this question. What is the proper knowledge base to assume in writing these questions? And I took a very conservative position. I felt that the proper knowledge base was only what was in the FE handbook. That means that little introductory section and the code. And my questions, the ones that I wrote and that are in there somewhere in the question bank, focus exclusively on those two documents. However, some of the questions in this review manual are much more wide-ranging, and as I said, in my opinion, are somewhat more controversial. I'm not prepared to discuss these at length. I think in most cases, common sense and your ethical background will stand you in good stead. But I just give notice that there may be questions on the exam of this more wide-ranging nature. And merely knowing the code will not in every case prepare you to answer these questions. And I think at the present time I don't have any more to say about the EIT manual. As I said, I just saw it a few minutes ago, but I'm just putting you on notice that there may be questions on the exam of a somewhat different character than the ones that I've gone over. I wish you good luck, and if there's anything that I can do to help you in the question and answer session, I'll be glad to do so. Thank you.